So lucky me, I'm having more skin cancer. But it's good to remove it.
Yes.
So anyway, so I won't be here tomorrow, but if you look at the schedule, I've taken up two bills. One of them's Senator Bowski's, and I think many of us have co-sponsored that. That's the contributory negligence and the civil action involving sexual assault. And the first one is has Senator Sheen's bill, which is an act relating to establishing two period judge positions. And we've gotten some information from, although they're not on there, Eric, I believe we have, joint fiscal has a fiscal note on it. We may want to add them to it right after Eric.
Sounds good. Yeah, I've been meetings with.
Forgot the guy's name.
Yep, I just have to figure out who's gonna.
So, and then at some point where we need to discuss other priorities in the budget. We're not do it right away, but the Attorney General's office is looking for two positions in local and municipal police departments, it's like north-south, for people that can help with victims of domestic violence specifically. Anyway, we'll get to that. And then Bob Paolini, the Vermont Bar Association, has an access to justice request of $500,000, which I don't know why the Bar Association would have that. Maybe we can find out too. So that's that. And then Friday, we're scheduled on S58, S285, which is a repeat of S6 that was vetoed by the governor. So the goal there is to find a path forward for that bill, which I thought we had our path forward when we went back to the Senate bill last year, but evidently the governor changed his mind. So we're gonna work on that and try to get the team interrogation bill. So anyhow, that's the schedule. So now to S209, there's been a suggestion to move the Big 12 offenses to S58. S58 is the fentanyl bill, and it'll require working with Michelle and Eric, but I know you two work well together, so I don't think that would be a huge problem.
Not a problem from our end.
If we move those out of, and just, but I need to find a place, either 285 or, 58 or 209 for the raise the age issue that we talked briefly about this morning. So I'm thinking that raise the age could go into 209.
Yeah, just so I understand correctly, Senator, were you saying take this section out of 209, but raise the age in?
Yes, and Ben worked on the language last year for raise the age
No, I did that.
delay.
No,
You did.
I did. I have it.
Well, you have the reports.
Right.
Okay. So I will work with you on the language. Is that acceptable to the committee, those changes?
I mean, I'm not opposed to the move. As you know, I have issues with the underlying policy, but the move is fine with me.
Thank you. I prefer having raised the age in ghost guns as opposed to the expanded Big 12.
Thank you. All right, so we'll work on, Ben and I will schedule Lael Chester from the Justice Lab next week, and Chris Winters and DCF folks to talk about raise the age. It's the 19-year-olds.
Oh, I got confused on which Ben you were referring to.
Pardon me?
I got confused on which Ben you were referring to, because then I thought raise the age was going in here.
It
Then I
is.
remembered you referring to
I'm referring to 209
Right.
for raise the age.
Right.
Raise the age 209, Big 12 58.
Gotcha. Yep.
All right, with that change, are there any changes to the ghost gun section 2, chapter 85, section 2 of S 209, which begins with a definition of
Are we just talking about definitions right now?
well, any changes to 209, section 2.
If I may, the thing that I want to try figuring out, if it's possible, is regarding the 3-day waiting period. I know I brought it up a couple times. My thought, given the intent and purpose of the 3-day waiting period and the fact that somebody already has in their possession an operational firearm, but they're just going to get it serialized, I don't know that it makes much sense to have the 3-day waiting period apply to somebody who already has that operational firearm, but they're just trying to get the serial number on it. I don't know if there's a way to work around that or if there's any suggestions, but.
Well, I see where you're going. The way I look at it is that person has possession, but they don't yet have legal possession of it until they serialize it and get a background check. So in my mind, they're just like everybody else who wants a gun. They have to have a background check performed. And so a waiting period for a standard waiting period from everybody seems the way to go.
Well, I mean, if they're going in there with the firearm that is in their possession, they are getting a background check to determine whether or not they're a prohibited person, right?
Yes, that's true. But I guess I just feel like putting them into the normal queue. Well, so we're talking about getting the serial number put on there. That's going to take longer than 3 days anyways, from the testimony we heard.
I thought it's done pretty promptly,
But anyway.
I mean, it's not gonna make or break the bill for me, but it's, I mean, if they're, from my understanding, the 3-day waiting period is meant to prevent those impulsive moments, whether it's suicide or homicide, and I agree with that, and I do believe in the 3-day waiting period, but in thinking about that purpose of the 3-day waiting period, if somebody already has that fully operational firearm in their possession, what purpose does the 3-day waiting period serve in that circumstance?
And the only answer I would give is that as we've had the discussion, there have been many times when people have wanted to carve out this group or that group from the overall regime of background checks and now waiting periods. So for instance, people had said, should you have to have a waiting period if you already own a gun? Because then if you were going to be depressed or angry, you already have the ability because you own a gun. And so people were suggesting that we not have waiting periods for people who already hold legal firearms. And my feeling is that to the extent that we start carving out this or that person for this or that reason from the regime, we'll wind up with a number of complications in terms of, i.e. loopholes, in terms of how people can, not have a waiting period, not have background checks. So I support everybody having, if we have waiting periods, everybody has them. If we have background checks, everybody has them. And we narrowed the Charleston loophole so that people have, if it takes longer than 10 days, they can get them.
Get away from the loophole, yes. Senator, but that didn't answer your concern.
I mean, I stand by my thoughts on it. Yeah, the last thing I'd want to do is unintentionally create a loophole that a different version of a Charleston loophole that maybe we're not anticipating. Because I'm sure if every loophole is anticipated, there'd be a way to prevent it from happening in the first place. But yeah, but like I said, it's not gonna make or break the bill for me. It's just a thought that I had regarding this, and if there are possible changes, I'd like to explore that. But if not, if it's unfeasible, then I'm not gonna definitely say no. So.
Well, yeah, Senator Miles.
My question is, or comment is a little bit moot. It was a little bit of a way into this conversation about, I guess I don't feel, I hear Senator Hashim's point and could certainly support an exploration of that 3-day window as long as we're not eroding at that 7-day extension to close the Charleston loophole some. But I also thought, have I missed hearing from someone who actually does these serializations as to how much time it actually takes?
I believe we have, because you said that Ben couldn't get a hold of Farrell.
And I couldn't get anyone to return my calls
We did have testimony from somebody that there were only a certain number of, I think it was maybe Chris, certain number of places in the state who could perform this, and that they are scheduled out. Am I remembering that correctly?
You are correct, sir.
Yeah.
But we also heard other testimony that was a bit of a misinterpretation, that only the level 3s could do it. It was like this other
We're
group.
still having a hard time finding you have somebody?
Henry Farrell, I
was trying to get somebody from southwestern Vermont where the problem is. And I haven't been able to, so.
The person I was gonna reach out to, in fact, has passed away, so.
Oh, wow, that's a good, it's gonna be tough.
Yes.
Well, we have Zoom.
Senator.
Can we Zoom from beyond?
Yeah, I just wanted to comment on the discussion that was taking place across the table here in reference to the 3-day waiting period, which everyone knows my thoughts on the 3-day waiting period. I wasn't for it. However, using Senator Hashim's example of the 3-day waiting period, and let's just use this term, I think we've heard this in this before, knowingly. If the person that I'm bringing that gun to knowingly has information that I purchased a gun 2 days ago, where's the incentive for someone to come in other than breaking the law to get a serial number on a firearm that he has to wait for, or she has to wait for? That 2 days ago they passed the
Well, I think to go back to Chris's testimony, people are gonna probably have to wait anyway, because they can't bring it in and have the person immediately serialize it. It would go into the chain, and, like when you take anything in to be serviced, usually it can't be done immediately. But I guess what I would say is, if you start from the point of view that somebody buys a machine and prints this in their living room, I'm speaking for myself, I don't want them to be able to do that and have that untraceable gun enter the system without a background check. So in my mind, if we're thinking about how to make it easier, so in other words, let's just say that the incentive is that they can avoid the 3-day waiting period by printing in their living room, that makes that preferable in some ways to buying a gun from a dealer. And I don't want to have a perverse incentive to people to print guns at home or to bend over backwards to make the regime easier for you.
This is what's stunned me all throughout this debate, is where the opposition is coming from. Because if I'm a gun manufacturer, I'd much rather have you buy my Smith & Wesson or Colt or whatever, direct from the manufacturer through my retailer, than you going home and putting your 3D printer I don't even have a 3D printer, but putting the 3D printer to work and building my own firearm. And, I'm now in competition with you, and the only thing that could possibly happen is that I have to go get a serial number if this bill passes. Otherwise, I don't have to do anything. I've now got a firearm that's untraceable, that's so-called. So that's where this, during the break, Tim and I were having a conversation about my surprise at some of the opposition. When people in Dorset, Vermont, home of the Dorset Field Club and other wonderful things, are making unserialized firearms out of a 3D kit. don't understand why we wouldn't oppose if you're illegally, particularly if your goal is to illegally transfer those.
And I take the point that people, you know, what's their incentive to bring it in, but, you know, people have the ability to make, you know, moonshine liquor, and that's illegal, but they have the ability to do it. They have the ability to grow cannabis illegally. They can do that, but what we're trying to do is make sure that the legal regime is as airtight as possible, and then make it harder for those people.
So, yeah, I'm just, anyway, Eric, going to, this issue, are we making it as easy as possible for somebody to get the serialization of the bill in your opinion? By copying other states, have there been any problems that, if we went away from requiring the background check, we would not be in the same league as some other states, is that correct?
That's true. I don't think that the existence or non-existence of these ghost guns or personal manufactured firearms, whatever the phrase one uses for that, I don't think there's any connection between the use of existence of those in states and modifications to the background check laws that also other states have. I'm not aware of that.
My other question is in the penalty section.
Mm-hmm.
Last year when we did unserialized firearms or defacing the serial, if we were to add to that, I don't remember the penalty exactly, but if we were to add to that unserialized firearms, the possession of, and use the same penalty.
Well, I think the possession is covered in this bill.
No, I know, but what if we went back to the same penalty we did
Oh, I see.
last year, so that it's consistent?
Yeah. That was 5 years and 50,000 for defacing.
Yes.
And that's,
In other words, just adding the word unserialized to that offense back that we did last year.
oh, I see what you mean. You mean, right now the language reads, a person shall not knowingly possess a firearm that has had the importer's or manufacturer's serial number removed,
Yeah,
or obliterated, or altered. And you're saying add to that, shall not possess a firearm that doesn't have the serial number on it, regardless of their
so it's
obliteration.
consistent offense, whether you defaced it or not.
Mhm.
I have another question.
Well, I don't know,
Sorry.
is there interest in pursuing having the offenses consistent?
Made sense to me.
Do you mean, so there's a substantial amount of other process and definitions involved in this bill. Are you saying to import all that into that statute? Or are you just saying,
The penalty,
take the penalty from that statute? Because you see the penalties that you have here, page 5.
strike the penalties that are here
Yeah.
and use the same penalty.
Sure. Say that's a 5-year felony.
Right.
And what is it here?
Here it's a first offense is a 1-year misdemeanor, the second is 2 years, and the third is 3 years.
But on top of the next page, the 5 years is currently, just to carry on with what it is under the existing bill, firearms for using it, who possesses it, the unserious firearm while committing a felony.
Right.
So I could, and this draws on, correct me if I'm wrong, Chris and Tim, but you were suggesting a harsher penalty if someone was, well, I guess in your iteration, it was the only penalty would be if somebody committed a crime with an unserialized firearm. So what if we had the felony penalty fee for that and then kept the misdemeanor for possession of an unserialized firearm? Better?
May I say something?
Identify
We had-
yourself for the record.
Tim Meehan with the Federation of Sportsmen. The biggest problem we had between us, we're responsible for trying to come up with a rational decision, was it got so difficult for us to take federal law as it currently exists, the current position where if you actually have a permission from the federal government to make a privately made gun, and then bring it up forward today where guns are being made non-serialized for the strict purpose of selling to criminals. Okay, we can't support that. We try to figure out, okay, how do you write language that will encompass that, will protect existing rights at the same time it gets at what you want to get at. And the only conclusion we came to, because I made the pitch internally, because of your district, which I'm very familiar with over the last 5 years, and the growth of drugs and guns, non-serialized guns in Bennington, that why don't we go, and Chris said, well, why don't we go right at it and make a very serious penalty for using or having a unserial gun, and make it a very serious penalty and a very serious fine. So we're with you on that we just couldn't figure out a way to come up with language, and we made the decision that you needed to have something done fairly quickly, and we thought the way to do it was through the penalties and fine.
Chris Bradley, President of the Federation, one of the things we circulated, there's been a number of court cases, and I think the Bruin decision is being weighed out in courts across the country as to exactly how to interpret the Second Amendment in SCOTUS's direction there. There was a case out of Delaware, and I think you can understand that a preliminary injunction is only granted when there's a reasonable expectation that the plaintiffs may win. I looked at the Delaware ghost gun bill. It is very similar, almost identical to what is being proposed here in Vermont. It's a difficult position for the Federation. We certainly can't support criminals having guns, and we were thinking beyond, as we mentioned, when you find somebody with an untraceable gun that's being used in felony crime, not only do we want to penalize them, in our view, we were looking to say, what is the lever that can get that person to speak to us or otherwise give up where that gun came from? So much of this is already covered in federal law. And in fact, one of the things I held back from suggesting, what if we find someone that's purposely making these things in their basement? It's no longer for, now bearing in mind that even with a 3D printer, if I sit down and make 3 frames of receivers, at least under federal law and ATF, as long as I'm not a prohibited person, I'm not doing anything illegal and I don't need to serialize. And I know that's difficult. How do you get someone who is doing this? But then again, we start bumping up to federal law. And ATF just rewrote these rules to say you're not going to sell kits that are unserialized, full 100% receivers. If you do sell 85% and you also sell these jigs, then you can't do that anymore either, because we're going to call that a gun. As you pointed out, Senator Sears, I think our FFLs have always been very keen on straw purchases. And because they are keen on it, and we've seen it over and over again, ghost guns become perhaps desirable. I'm not sure I would want to fire a ghost gun pistol. But if there was an accelerator, not only for you get caught in a felony using one of these things, put the bar up high, because I want you to talk, and I want you to talk as to where you got it from, so I can now chain the next person. I'm sorry.
Senator Bowles.
To the initial question of like aligning the penalty for possession of any unserialized weapon, regardless of how it became unserialized, I see a difference between taking the action of filing off a serial number versus purchasing a kit that didn't have one and going in to get one. So I do see a distinct difference in the action taken. So I would be a little hesitant to fully align them, somewhat like what Senator Baruch had suggested, sort of leaving the simple possession as a misdemeanor.
I'm willing to leave in what's on page 5, the ABC. But in 2, I think it should match, it's just the person possessing an unserialized violate while committing, I don't even think it should be a felony by committing any crime. Should be consistent with the serialized, unserialized. Because, any crime, I don't care whether it's a felony or. What if it's misdemeanor domestic assault? So those two should be consistent. That's my main goal here.
Right.
The second, if we're okay with that in a redraft, my second issue is, we were gonna deal with,
Can I jump in just for a second before we leave that one, Senator Sears?
Yeah.
Just one editorial suggestion too, is that, and I think I was sort of basing this a little bit on the existing statute, which we've talked about in this committee many times with respect to the Big 12, the existing statute on carrying a firearm while committing a felony. So it occurs to me that you may want to just change possesses to carry, because that's what the existing statute uses for, rather than have courts look at it and think, did they mean something different? When I think what you're getting at is the same thing. Assuming you don't want to use the word using again, which you were thinking about, which is obviously an even more, do you want to, you were just talking about changing it in the Big 12, that's a policy call for you, but I'm just flagging that. But if you want to keep it in terms of this, whether they just have it on them, I think it should be carried. Just because that's the language used in the existing statute. Thank you.
Did that solve your issue?
Yeah.
I have one on page 6, and I might, it may be elsewhere in the bill and I'm not finding it, but it's talking about serialization, and it says at the bottom of that paragraph, the serial number to be at the minimum size and depth and not susceptible to being readily obliterated. So I'm thinking, and I forget whose testimony this was, that in order to make that the case, you'd have to have a plate. Because if you put it into plastic, the serial number, it would be relatively easy to scratch off. And I'm wondering, is that spelled out somewhere, or is that language in case law that?
From the federal regs, that's where that came from.
Yeah, I think this is, my note is that this section is consistent with federal regs.
Great,
Federal law.
So people would know that if it's a plastic gun, there would have to be a more durable addition to the gun.
I think that's right.
Okay.
Then it gets, is,
Oh,
this was on page 7, line 5. That's consistent with relief from abuse orders. Because we're saying that this person, if they're found to not, if they're not supposed to possess a firearm, they shall surrender the firearm, frame, or receiver.
well, it says the licensee shall surrender.
Huh?
So it's the FFL.
Right.
Right, it has to do that. Is that consistent with other places where, in the background check law that we did? I know I had a note that it's consistent with the relief from abuse order, but I'm not sure it's consistent where why would somebody be in the? Well, that's probably we ought to hear from Mr. Pirro. But we're putting the onus onto the federally licensed firearms dealer to take the firearm, not police, not law enforcement.
Hard to imagine how the police would do that.
Yeah. Yeah, I don't know how anybody does this. So I bring the 3D printed firearm in. The background check's denied. And the federally licensed firearm dealer is supposed to take my firearm. You know, we put that into their responsibility elsewhere.
That's what happens.
That's what happens.
If you had a plastic or polymer receiver and you wanted to do anything with it, transfer it, the FFL may or may not take that into his inventory. He can say, I don't want to touch it. If he does take it into his inventory, he has to serialize it or authorize someone to serialize it within a certain period of time. Once that serialization is done, before the person can get it back by ATF law regulations, a background check has to be done to return the gun that was already his after it's serialized.
Yeah.
And chances are,
Well, that's the difference. When I go in to buy a gun and I'm found to not be able to possess. Nobody's taking anything from me. They just won't sell it to me. In this case, we're actually taking my firearm.
well, the ATF is. This is all under federal law,
Oh,
not
okay.
necessarily anything.
All right.
I'm sorry.
No, I just, Senator Bahalski, you have a solution?
I don't know if I have a solution, but it brings me to the possibility of that sort of 3-day window being helpful in that that the person isn't going to be standing there waiting for me to hand it back to them.
Right.
And if the background check does come back that I need to, I can then call the ATF or the police to come be the one. So it is not me that is like, sorry, I'm not giving this back to you. But instead there can be a window of sort of getting the right agency to come do that.
I'm thinking of, also when my sister and my nephew right now work at a liquor store. And people come in with fake IDs all the time, and those are confiscated. And people always say, I paid for that, I want it back.
That's illegal.
Some of them get angry. It's a different level of threat when it's a gun that's being, but I, to my mind, if somebody brings in a weapon and they're found to be a prohibited person, at that point, the FFL dealer's got it behind the counter and has theoretically security of some sort anyway.
Just found it to be something that I would want to do particularly.
Yeah.
Yes.
I might suggest a polymer receiver or a frame now needs to be stamped with a metal plate. You heard testimony where these things are actually made with that plate inserted in to take a piece of plastic and then just rivet a piece of metal on it with a serial number. It will not fly up by ATM. The FFL won't do it. And chances are, if you have one of these things, you're going to know you can't do this, and you won't try to follow through because it can't be serialized in some cases.
I guess the final question from me for Eric is, have you done any work on the trigger? I saw a series of emails on the trigger. It's a item that allows you to make it into a machine gun type.
Yes, and I can't remember if I sent that to Ben or not. I may not have.
The box, which.
Yes, did I did that one?
There should be,
So you-
Auto seal.
there should be, print out hard copies with all the.
Right.
We've got them here.
Yeah, basically bump stock is meant to do the same thing. What's the definition of the bump stock?
I was looking at that. They, depending on what definition of that some states use, it would include a bump
Okay.
stock.
All right.
But others don't.
Is this document here?
An auto seal is
If you're looking-
a little piece of metal.
Yes.
Inserted in.
But for the same purpose.
it renders it full auto as opposed to a semi-automatic bouncing. A
Yeah.
full auto, there's no mechanical brake.
I guess my point was just that we've already prohibited bump stocks for that reason. So it's, because it's allowing a much higher rate of fire.
Mhm.
So it seems like we're pursuing the same thing. It's just a matter of capturing it in the definition.
There's a document here with
I can see
Illinois,
where they might be happy.
Massachusetts, Illinois, and Texas.
Well, the three examples you should have in your folder. I think as far as,
Texas is the simplest.
and I was also gonna say the easiest to work into the bump stock statute, actually. It's gonna show you that here. Pull it up. Yeah, there's the Texas one. I don't know if you can see it from there.
Naturally, Massachusetts is the longest.
Right. And that one would encompass bump stocks, whereas Texas is distinct, I think, the way I read it.
So we're running out of time, but we need to settle on whether or not we're going to do this, and if we do, which state should we follow? Are we, majority feel that we should broach the subject of the trigger?
So would we be, I guess I'd want to see what we're adding.
Well, we're adding either language from Massachusetts, Illinois, or Texas.
Can I just take a look at that? I don't know if I have it.
Everybody should have that.
And so we'd be doing this, prohibiting it in all weapons, including ghost guns? Okay. I mean, I wouldn't have a problem with it at all.
But my understanding is that ghost guns, if you can create a machine gun that fast with the.
I see.
Oh, thank you. You can keep that copy.
Okay.
There's also the Federal Register has a discussion of the highlighted pieces. But I think that's the goal here is to prove that. Yes, sir.
Bump stock is a very specific piece of equipment that was designed to, just so you know, a rubber band, a piece of string, a belt loop can all answer what I see in Massachusetts, because you can, with a simple rubber band, playing games with the trigger and the operating rod on the gun, you can. I understand the intent, but you're looking at things as simple as a string or a rubber band being qualifying for that. And then we have something called constructive possession, where if I have a gun and a string, am I guilty even though they're not related? And I can have to.
So you disagree with Texas?
I haven't seen.
Texas is a very simple one.
The great state of Texas?
It does say a device designed and intended. I don't know if a rubber band would.
Be designed or intended for that purpose.
To make a handgun capable of automatically shooting more than one shot without manually reloading by a single function of the trigger. Texas it is.
Well, a single function of the trigger would be a fully automatic.
I'm assuming that either Bush or Bush or what's his name signed Paxton or whatever his name is. Abbott.
The trick is a single function of the trigger.
Barbed wire Abbott.
The trigger would be a fully automatic weapon.
I understand.
As opposed to something that's simulating a trigger pull.
I'm just saying, if Texas did it, probably okay.
I'm not sure that it's been signed by the governor. It was, and in fact, I think that it was passed, one version by the House, another version by the Senate, and I think that's where it sits. So
Then the governor's a squish.
All right, well, there goes my argument.
I do think that that is important, an important distinction from a rubber band, is the
Yeah.
language of design.
That
and
is
intent.
designed and intended to do it, yes.
Like, it acknowledges that, yes, there are ways of
Yeah.
maneuvering all kinds of things to do things
But
they
the
weren't
rubber
meant to
band
do.
is not designed and intended
Exactly.
to create that. All right, we're gonna come back to this next week. But I think we could probably put together an amendment that does everything but the trigger at this point, and we're gonna try to hear from an FSL.
And that, so don't include the trigger piece yet, the one we were just looking at, you mean, or
Pardon me?
did you say include this part we were just talking about yet, or hold off on that, the trigger?
Hold off on the trigger
Okay,
until we can get more information and have a further discussion with the committee, but
right,
I'm leaning towards Texas.
okay.
I've always been impressed with Texas. They're a rather large state.
They are large.
Do you know that Vermont and Texas have a good relationship in terms of corrections and the efforts at justice reinvestment?
You know, I did not.
We're actually doing training and recruiting in Texas because both states have problems with recruiting corrections officers.
Probably all the states have problems
Well, yeah,
with
but-
corrections
but
officers.
There's a agreement between the two states to work together and, devising ways to. We have great relations with Texas.
I did not know that. Most of my policy knowledge in Texas is around elections law.
Anyhow, so the amendment will go back to if you could repeat the language from last year on the written
Yep. Absolutely.
and then we can discuss that and schedule Lael Chester from the Justice Lab and update the reports. And I'm thinking off the top of my head, to get DCF to talking. I'm setting a date of March 31st, 2025. Which means if they want to slow it down, they need to do it in the budget adjustment. That gives them approximately a year to get it done. Traditionally, we've been using July 1, this is for discussion purposes only, thinking of March 31st.
For,
If you delay discussion purposes only,
okay,
delay the implementation of raise the age for 19-year-olds, gives the administration approximately 9 months in 24-25 budget year to develop the programs necessary and to have it go in effect on the 31st
okay,
of March.
2025. My brain was thinking
2025.
2024. I was like,
Yeah, I
that's
know.
sooner than July. Like, what?
It would give them 9 months, assuming that it's the bill, effective in the budget and all that, gives them some time. But it would force some action before we get to the end of the session next year if they want to try to delay again. And it also makes it more, because the report is positive for those non-Big 12 offenses. So with that, we'll turn our attention to S58, which, Eric, you're gonna need to work with Michelle on the Big 12.
Right, and just one last on that, if you want to, before I get the language to Michelle on that, was there any thought on the crime victim piece, or remember we were talking about the exceptions that you had carved out from the additional offenses that are added to the Big 12? First action.
Attempts. We should have added attempts.
That's in there. But I mean, that you had heard testimony from Tim Letters-Dumont and Jen Pullman this morning about, some language.
Yeah, I think the issues is particularly on the human trafficking.
Right.
Thank you.
I'm wondering if we should even do it, human trafficking. Um, So that's one area of debate.
Right.
If you do human trafficking, how do you separate out the victim
Right,
from,
exactly.
and how do you, the discussion with Senator Bowski and Jen and Tim as well regarding looking at a 14-year-old, do you see them, you know, actually being the trafficker and not the victim? So that's one decision. The second decision is if we add, how do we deal with breaking and entering into an occupied dwelling? The points are well taken. And the idea is you can move any crime up, my understanding. So if it's particularly egregious case, you could move it up to an adult court. If you took out number 12 completely.
Right. It'd be subject to the motion and hearing process, not automatic.
Right. You'd be subject to the motion and hearing.
Right.
And then, so you'd be left with, using a firearm and Commissioner, making sure that is the situation I described in Bennington with the firearms on the coffee table, not necessarily using them, but certainly intimidating them. The second would be the drug trafficking, and the third would be aggravated stalking. So that's one possibility the committee could discuss. Or further refining the occupied dwelling. The other thing that I don't know where to go with the occupied dwelling. I honestly don't. I don't know where I stand on that. It is a serious offense. It is a dangerous thing.
And I agree, I don't feel like it necessarily belongs in an expansion of the Big 12.
Yeah. Maybe, is there a special route for it?
Well, it's in the Big 12 as it is.
Right.
It is number 12. The proposal was to limit it so that.
I'm sorry, I didn't understand that.
Yeah, existing law is that the building doesn't necessarily have to be currently occupied.
Huh,
As long as.
Those are the court rulings that have caused us to want to relook at it. And
Right.
we asked the Sentencing Commission to look at it last year because
I would be for
the
eliminating.
example of the hunting camp that is occupied 2 weeks a year. And somebody goes in March and gets charged with breaking into an occupied dwelling has actually happened. And they're charged as an adult.
Yeah, my brother, when we were kids, he had a friend that my parents called a bad influence. And they broke into a bunch of houses and took stuff. They weren't looking for guns. They weren't even looking for money. They were just kind of looking to commit little crimes. And, my brother never developed a record. It was sort of handled within the neighborhood. Parents came over and there were, this, that, and the other thing. But to think that would qualify as something that needed to start in adult criminal court, it just doesn't work for me. But I'm startled that it's current law because.
I would certainly support removing that, as I'm sure comes as no surprise to you, given that my position is that we should eliminate them altogether. My other thing I wanted to raise is Jennifer Pullman had also said that they would support raising the age from 14 to 16.
For everything.
That's what it sure sounded like she said to me. That was a proposal they
I thought that
discussed.
was I thought that was human trafficking.
Now it's 14, right?
Mm.
So there's 15 or 16 as possibilities.
I can't support that without a rapid way to get up into the system. So there needs to be a better way there would need to be formed a better way to go from juvenile to adult in cases that involve the Big 12.
Right, it's like the current Big 12, the prosecutor has the option at the outset. I can file in the criminal division, or I can file as a youthful offender in the family division.
Right.
So, whereas if they started in family, then in order to move up to criminal, it's gotta go through the hearing process. Now, that's policy call for you, but just so you understand.
It's a
Two
difficult
groups.
process. And yes, Senator Rush.
I was just gonna ask Eric, can you remind us what goes into the hearing process? What's required? What does the prosecutor have to prove in order to move from family to criminal?
I know where the statute is, but there's a lengthy
It's
list
a
of
long,
factors
it's a
that
long,
they
hard,
consider.
arduous task.
So, I can't say it off the top of my head, but I can certainly send you that.
It's not designed to be used infrequently, and that's part of the problem. And so unless you have, if you wanted to do what you're suggesting, which is what we did for 12 to 14-year-olds a few years back, you need to have a way to get that case moved.
My understanding, though, from all the testimony we've heard, is that the kids who end up being charged in adult criminal court are the exception to the rule, and so it would be used infrequently. Everything I'm hearing is that the vast majority of these end up being transferred down to family court, so it would be used very infrequently. So the fact that it's designed to be used very infrequently almost seems to fit quite well.
Senator?
Question, I'll ask Senator Baruchoff, whatever, I don't know what his concerns are, but my question, Eric, is in reference to juvenile and adult court, an offense has been committed. In this particular case, the very confusing burglary of an occupied dwelling. What are the penalties versus one court versus the other court for this? Are they the same, or are they?
No,
They're not.
If you're prosecuted as an adult in the criminal division, you'll be subject to the statutory penalty for burglary, which I think is pretty serious. It's a very serious felony. I'm not remembering the number off the top of my head. It looks like it is 15-year felony, $1,000. And if it's an occupied, right, and then it goes up, actually, there are 25 years if it's an occupied dwelling, except so serious felony. Whereas if it's a juvenile case in the family division, it's not a criminal offense, you're not imprisoned, you are given a treatment plan by DCF, and you will age out of the system at whether it's 18 or 19, depending on where it is, but you have confidential proceedings that do not subject you to incarceration by Department of Corrections, so it's a different world.
So, my follow-up question to that is, what about for a second or subsequent offense? Is that person still eligible to be moved from family court, or to go into family court for second offense or for subsequent offense?
Yeah.
How many times are we gonna do this? I mean, is my question. I understand your concern.
Yeah. You mean, so somebody, if we removed it from the Big 12, somebody committed burglary into an occupied dwelling and they got the lighter penalty, then if they did it again.
Exactly.
I don't know how a court would look on that.
Are they eligible is my question for.
Well, it seems to me like if we had removed it from the list, it would go back into family court. But if you were going through your second time around in family court for the same offense, you'd probably get a harsher penalty, wouldn't you, Eric?
You mean if you, well, first of all, there's, as we were mentioning, there's the possibility that subject to a hearing, it could get moved up to the criminal division. Again, one would think that if it were a second or subsequent offense, that would factor into the court's decision as to whether or not to send it up to the criminal division. So nevertheless, it's still.
Maybe it becomes one of those rare cases that get moved up because it's a second or subsequent. But my way of looking at it is if a juvenile, let's say a 13, 14-year-old breaks into a house and they commit no other crime, they don't injure the people in the house, they don't brandish a weapon or threaten with a weapon, they get caught like rifling through a cupboard or something, that in exclusion, to me, doesn't seem like it merits adult criminal court. But if they committed one of these other crimes, like they had a weapon with them while they committed that, then I can see it. But, you know,
If they take a weapon when they're exiting, is
yeah,
that the same thing, or
you mean if they steal a weapon?
steal a weapon?
But then that's a serious crime that they can be charged with too. So I'm just thinking of, in isolation, a 13 or 14-year-old breaking in, which could mean, correct me if I'm wrong, it's just that you're uninvited.
13 would be,
Let's say 13.
14. 13's automatically starting.
Okay, 14. So if the door's open, the back door's open, Aaron,
Right,
but they're not invited, that's still breaking in.
correct.
So they come in the back door because they know that there's a liquor cabinet there, and somebody told them that they went in and got liquor out of the liquor cabinet, and they were caught. To me, that's kid stuff. Like, to have them be caught up in the same net as somebody who's doing more home invasion style thing. I don't know. That one stands out for me as,
I'm gonna make a suggestion.
yeah, okay.
Number one, that we look at what I consider the most important addition to the Big 12, which is the firearm.
Yeah.
Use of firearm, committing a felony. I think that's tremendously important. I think that looking for ways to move up and down in the system would be a good report to have back from the Sentencing Commission, to be very specific about what we're looking for, is how to move from, if somebody commits a crime, to encourage. If the movement was easier, I think state's attorneys would be more likely to charge in juvenile court, if they could move up easier, when there's some doubt about the case. So I think the Sentencing Commission did a good hard study of that. I think we as a committee should decide whether we want to keep the occupied dwelling in as a Big 12. And let's take a hard look at the other three crimes: aggravated stalking, drug trafficking, and human trafficking, as a further discussion point in committee. But I'm not sure we can fix the problem with the occupied dwelling. So I think there's 4 discussion points. One, take it out completely and just make it 12, but the new 12 is the firearm. And let the other 3, I think there's arguments. There's certainly arguments on the human trafficking that have, after the discussion this morning, have me wondering whether it should even be there. It's unlikely that somebody 17, even 17, is gonna not be a victim. So that discussion, I'm willing to look at. So I think if we can agree that at least addition of the firearms should be in there. It deals with some of what we're seeing in juveniles.
And I really like the idea of pulling one out and putting one in and having it remain 12. It seems to me a very neat solution.
Well, and we can get information from the crime research group,
Yeah.
hopefully next week, on the number of actual charges in adult court for that crime.
Yeah.
It may be very rare.
I've already put in a request for that.
I appreciate that. So why don't we move on to the fentanyl portion of the bill with Michelle, and see if that's something that could get the majority of us to support. But I really think the Sentencing Commission needs to look at how you get in and out with these serious crimes. Because I think if it was easier in the case in Bristol, it might have gone the other way. That's the one where the kid was brandishing a gun charge of murder an adult. But it may be because the state attorney saw how difficult it is to move it up when she starts a new family. She chose to go with that.
One of the things that would be helpful for me, and maybe Eric, this is a question you can answer. I've heard conflicting testimony as to whether or not it is actually the state's attorney's choice to file criminal charges or juvenile charges, or if the Big 12 in fact must be started in adult court.
No.
I've heard conflicting testimony from multiple people that generally I feel like they know what they're talking about. So I'm
There's no requirement of a must.
No, the law specifically says, and there's a carve out. It says those cases, the Big 12 shall be filed in the criminal division unless the state's attorney direct files it as a youthful offender proceeding in family 12. And then that's relatively recent. That's sort of part of the raise the age. That was part of that whole, over the last few years that was added, but it's called a direct file. And it's an option available to the essays. I've spoken with Tim about that, and we can confirm that.
Thank you. That's just really, it was really confusing because I was hearing multiple different.
You know, I've actually known cases that have been directly taken to youthful offender and dealt with rather quickly. And, you know, the agreement is if you don't get in trouble for 3 years, we're gonna dismiss. If you do, we're gonna get you, we'll bring you back to court. And then they're sort of diverted. They get services from diversion, get services from DCF and supervised by probation by calling in once a week or something like that.
One thing that's sort of interesting about it is that in order to qualify for the direct file has to be a case that would ordinarily be filed in the criminal division.
Right.
So it really has to be a Big 12. So it's interesting that to have that option, the youthful offender option, at least the direct file way, to a non-Big 12 offense, it's not available. You know, in one of those cases, there has to be a motion to treat a case as a youthful offender. You can't direct file unless it's a case that would otherwise be a Big 12.
But isn't youthful offender like that explicit group of young or sort of older teenagers and not actual, there's so many terms that are flying around that my brain is now just.
They can be older, but they still start
Part
at
of raise,
14 or
part of raise the age was some additions and changes to the youthful offender statutes to allow more use of youthful offender so that you had the benefits of both DOC and you had the hammer of, in serious cases, if you needed to bring an adult charge later because the person failed consistently, you could do that. And it's been fairly successful to my knowledge.
Yeah, that's the difference. It doesn't necessarily stay in the family division. If the young person doesn't comply with their probation, then they can get bumped back into the criminal division and then they get the criminal penalty. It's sort of, that's why they call it the blend, or they used to call it a blended sentence.
Okay, so maybe I now understand. There is no direct file to family court. There's a direct file to this middle ground space of youthful offender allowed.
But it's in the family division. So it gets all this treated as a juvenile case in the sense that in terms of the consequences, confidentiality.
I'm sorry we don't have a chalkboard in here.
I feel
Eric can draw you
the play map?
the play map. But it goes into, the youthful offender is in juvenile
Correct.
Okay,
court or family court.
but DOC is still involved.
DOC is involved
Yeah.
if the person, usually only peripherally, and only if the person is causing problems. Usually the probation officer will talk to them.
I think they have to make a joint case plan, right?
They
DCF and
jointly, you know, it's, the idea is probation officer and social worker and standing over a water cooler and talking about Joe, and Joe is screwing up, and it's time for you to have a chat with the probation officer and let him know what might happen if he continues to screw up.
Okay, because I feel like we've also heard testimony that if these are in the family division, there are no consequences, which I'm now hearing through this youthful offender process is unequivocally not true.
No, there
Okay.
are consequences. There can be
YO cases, for
Okay.
sure, yeah.
There can also be intermediate consequences. In other words, it doesn't have to be that the judge sends you in adult court to the actual crime that was committed, that you were found guilty. It could be that the judge says, you're gonna go to drug treatment, and if you don't, this is what's gonna happen. That there's all kinds of intermediate sanctions that can occur.
I appreciate you bearing with me trying to suss out our
It's complicated.
complex system.
It's part of the complexity is because we don't have the numbers to have our own youthful offender system. Most states have their own youthful offender system with youthful offender facilities, et cetera. We don't.
But I do think I understand now. And I think some of it too has been some of the conflicting testimony. I'm like, wait, which of these things? And it's because there's multiple
Poor
factors.
Michelle's been sitting here
Thank you.
for half an hour. So,
Well, plus this will soon be part of your bill.
Oh, yeah.
But I'll come in for that part, we'll work it out.
okay, so we have a,
Okay. Just relax, it's okay.
oh my God. This is gonna be very difficult, Michelle.
What is?
Section 5, it cannot take effect on July 1, 2023.
You looking at the amendment? Did you print out?
No, I didn't realize, sorry, I thought
You're
you.
gonna pay.
No, I'm gonna pass out. What are you guys looking at? The bill?
That's the-
July, effective date,
Right.
July 1, 2023.
But,
Okay, so we're not looking at that.
right, I'm gonna pass out for
Yeah.
you,
Okay.
an amendment I have for you. And we can, and the effective date, be
Oh, I
obviously
know.
whatever you want.
I just wanted to start with something everybody could agree on.
Right.
So should we walk,
Well, we
should we
have
work from the
hallucinogens
back?
in here.
Yeah,
We
what?
agree on
From the bill?
hallucinogens.
Oh, yeah.
Um,
Definitely.
I also, I'm passing out for you, something, so after your last meeting, we were talking about the penalties for trafficking and whether or not there should be mandatory minimums, because you have statutory, large statutory maximums currently and, of 30 years for trafficking. And so, at your request, I followed up with with Robin Joy, and she was fabulous as usual and quickly put together a chart for you. And so I know you have some time scheduled on S58 on Friday morning. So if, and I told her I'd, let you know that, if we'd connect if you wanted to hear from her on Friday morning about kind of parsing these numbers a little bit. But you can generally see on the chart that they provided, the offenses. So you only have trafficking on offenses for cannabis, cocaine, heroin. And then I also asked her for the sentencing information on dispensing or selling with death resulting. And so you can see there the average minimum years for sentencing, max years, days served, and charges.
Can I just get a copy of the bill that I don't have
Oh, sorry
the
about
current
that.
drafts. Thank you.
Oh, I gave yours to Ben.
No worries.
And I don't have that chart.
Awesome.
We went around.
There you
that
go.
to Ben.
There's another
Thank
one.
you.
That's okay. I already gave Ben. I'm still
Now I
working,
have
I'm still
two. I have
working
a-
off the old system where the lawyers would always bring their copies and then give one to Margaret Lucente or whoever's occupying that chair. So, so you have those numbers, and
Yep.
so you can see
Yeah, let's-
what the current sentencing information is.
So the section 1, the only change is adding xylazine.
Right, so we're taking a look at strike all amendment. There's some highlighted language for you to take a look at. The two things here are, one is the addition of adding xylazine as a regulated drug under Vermont law. And then the other issue is related to flash citing someone who is found to be dispensing or selling in a dwelling and the conditions of release that could be ordered. And so with regard to the xylazine, it's, we've already talked about it a little bit. It's an unusual situation where it is not part of the, it's not listed in the Controlled Substances Act at the federal level. So there is legislation in Congress to put it as a Schedule III drug. And so some of the language that I have in here, I picked up from the federal legislation. What I've done just here to kind of get you rolling, but I think it is it's kind of a new uncharted territory, and I think a lot of states are obviously trying to figure out how to approach this, because it is a drug that is not a controlled substance, but does have valid uses for veterinary medicine, and you, my understanding is you want to preserve those. So what I've done in section 1 is, so in your definition section of a regulated drug in Title 18 and Chapter 84, it goes through and it spells out what are regulated drugs. And so you would have to add xylazine because our kind of catch-all language, which is on subdivision 29B there, which is depressant or stimulant drug other than methamphetamine, and then right above that, a narcotic drug. You have kind of a catch-all statute that provides for penalties that aren't specifically listed for certain drugs. So like OxyContin would fall under the narcotic provision, things like that. And again, I have a very limited understanding of the chemistry and the kind of all the health stuff around xylazine, but my understanding is that it doesn't fall into those categories, so it would need to be just like you have ecstasy listed specifically, it would need to be listed specifically there. So what you do by adding it into this definition is that all of the provisions of Chapter 84 around regulated drugs would apply. So we're adding it to the definition there first of regulated drug. Then the next piece of that, also, sorry, on page 2 is I added a definition of xylazine. I used kind of a short definition. If you look at the federal legislation, it lists xylazine and then it goes through a list of all kinds of different chemical compounds and formulas and things like that. And when we heard from Trish Conti from the state lab last week, I'd asked her whether or not there needed to be a very kind of specific definition of xylazine, and she just said xylazine is xylazine. So I don't know whether or not this is sufficient. It might, I think probably you'll want to circle back and have the health department weigh in on this stuff to make sure that we're getting it right. You could add in all of those other things, but you generally don't see that in the Vermont statute. You could say, or, as the health department designates by rule xylazine. So if they need to kind of tweak what the formulations are. I remember when you were doing the ecstasy bill, one of the issues was that I remember some of the testimony was that you could kind of tweak the recipe for the drug, and then it would all of a sudden kick it into some other category.
What I'm gonna do is ask Ben to send, or you can send this to the Department of Health and ask them to look at it and get back to us next week on whether or not the definition works or not. But what you're trying to accomplish is, if I understand correctly, is to make sure that it's still legal to possess xylazine. It's illegal to knowingly dispense it or sell it to a human being.
Correct, and that's what you have in the next section, in section 2.
And as long as, that was our goal, my goal anyway. And the knowingly does match the definition knowingly on the fentanyl on the top of page 2, 4.
Yes, that knowingly would apply throughout Chapter 84.
Okay. So,
I had a question about the definition of xylazine on line 9, page 2. I'm remembering the state's attorneys in their amended language, they were saying that any baggie containing any amount of fentanyl, the entire thing would be fentanyl. And in our discussion, we had some problems with that because it could be a molecule or two of fentanyl and then mostly inert substances or whatever, but in terms of the amount that they would be charged with, it would all be considered fentanyl. So they changed that, or we didn't allow that into the bill, as I remember. But
No, I think that is, I could be wrong, but I know what you're talking about. And I think that is part of like the larger discussion about how they approach these and how they do the measurements for the increasing penalties. And so I think probably you just need to have a conversation with the state's attorneys again about how they approach that, because
what I'm wondering about is if we're defining xylazine as any compound or mixture containing xylazine, I read that you could have 100 pounds of something and it could have a little bit of xylazine in it. And under this definition, that would be 100 pounds of xylazine, which either we would create penalties that would be wildly out of sync with the actual amount of the drug, or our definition wouldn't work. So, I don't know.
Well, then my argument would be it's not the possession that's criminal. In this case,
It's the selling.
But selling it or dispensing it is a crime.
But I'm thinking there would be different penalties for somebody who sold a little baggie like this, and somebody who sold a brick of it. And at least every drug.
I'm trying to remember Trish Conti's testimony. If it contains fentanyl, it's 100% of the bags contain fentanyl and 51% of the bags contain xylazine. But what if it's a combination of xylazine and fentanyl, or cocaine and xylazine, or heroin?
Under these kind of definitions, it would be 100% fentanyl and 100% xylazine.
Right.
So I'm just thinking, I understand where we're going, which is we don't want to have to get involved in separating out chemically and determining how much of the mixture is.
Right.
But that still leaves, for me, the problem with the definition that to make it convenient for ourselves, we're just saying that any presence of xylazine, why is that?
Okay, I was like, did you hear the Senate bill?
Yeah. So I just note that.
I completely understand that, and I think, but just so you know, that is how our drug, like if you look at the heroin law, so heroin, a person possessing heroin in an amount consisting of 200 milligrams or more of one or more preparations, compounds, mixtures, or substances containing heroin shall be in prison not more than 5 years. And you go up and then same language, except if it's a gram, then it goes up. And so,
it just seems weird, because then it's like our judicial system and law system is saying, it doesn't matter how much you actually had. It's more like fraud. It's like you're representing this huge amount as, I don't know.
I think, and I could be wrong, but I've been viewing it as, perhaps maybe back in the olden days when these statutes were written primarily in the 80s, not that there weren't cutting agents and things like that, but that what was marketed was what you were generally getting. And that perhaps things have changed. I don't know, but I do understand certainly your point, and I think probably speaking with having all the players on Zoom, where it's state's attorneys in the lab and talking about how that works.
4 minutes left.
Sure.
And I'd like to really look at your unlawful drug activity in the dwelling flashlight so that we understand it, and hopefully that.
Yep, so that is, just the lead-in is on, this is not that, is section 4. And so you look at the language at the top of page 5. So you recall that last year, one of the bills you did was you, I think, tweaked 18 VSA 4252 around knowingly permitting sale of regulated drugs in a dwelling. And so what I've done is created a new statutory section right after that in this chapter that allows for, so you have a provision in the domestic assaults subchapter in Title 13 that allows for flash citing in domestic assault cases. So that is meaning that, like, let's say if somebody is arrested or cited, and then they're given a citation and say, you are to appear, before the court at this date out in the future. However, with the domestic assaults is they flash cite and that the person is supposed to appear for arraignment at the next business day. So just kind of the thing that we've been talking around, with the courts and things like this, which is kind of just an immediate response there. And so this is following the model for that language that is currently available for domestic assaults, so that except for good cause shown, a person cited or arrested for dispensing or selling a regulated drug and violated the chapter, so it would be any type of drug, shall be arraigned on the next business day after the citation if the alleged illegal activity occurred at a dwelling where the person is not a legal tenant. And so then the other piece to that is the subsection B, which is that unless the person, maybe they have other charges related to that and there was a violent offense and they're permitted to be held without bail, but if they are bailable, then they would set conditions of release. And that one of the things that the court is to consider is to essentially, just like you would with, let's say, an RFA or something like that, say you are not to come back on this particular property, you're not to come within a certain distance of that property or be hanging out in the driveway or the parking lot of that apartment building or whatever it is.
Good work. So we'll pick up with this next week.
We do have more discussion on F58 scheduled for Friday morning, but that's.
Oh,
gonna focus on-
okay, so we'll pick up with this Friday
That's
morning.
gonna focus on the eviction aspect.
But there's, I think, quite a bit of time, and I don't think,
I
we don't have much more. John is working on shortening the time periods for that.
How can you get any shorter than?
Well, no, on the eviction process.
Oh,
So
oh,
around
oh,
if
that's
someone who is engaged in a legal activity and you have that shortened notice period, we're looking at whether or not we can kind of speed it up a little bit. And so that's a whole separate thing. What you have here in this language is if that person is not, they're not, on the rental agreement, they're not sublet, this is just like a guest, like the kind of
Right.
circumstances like you were talking about.
And I do have the sheriff scheduled, and they just talk about what their system is.
Friday, we pick up with this and maybe if we can get a hold of the Department of Health and Trish Connie to take a look at the drug piece. Yes, sir.
I would also really like to hear from the Defender General for, at least for Section 3, regarding the changes to the defenses that are incorporated there. For page 4, if you're looking at what we just received,
Oh,
from line 4 to 9, essentially.
okay. What would you expect to hear?
But they're not in support.
What page is that, Otter? I'm sorry.
Oh, my
3, 4, page 4.
Page 4, lines,
4 through 9.
Yeah, it hasn't been edited, but.
okay, the fact, toward the end of.
Well, ask the state attorneys and the Defender General to join us
Oh, okay.
Friday night.
All right.
All state's attorneys are able to do,
All right, well,
Get written testimony?
I can talk to them.
I mean, whatever you want, but.
yes, ma'am.
I also still think we need to hear from the ACLU and the Director of Racial Equity on this bill as a whole.
Can't hurt.
Well, why don't we just,
Table the bill.
I would
Well,
be very supportive of that.
I think it's a fair request. you know? To have, because there are gonna be two sides and two basic responses to the bill,
I have to ask where they've been.
where they've been.
Well, usually people come forward and say, we'd like to comment. And what's happened is they don't.
Oh, I see what you mean.
And all of a sudden, as we get towards the end, they come in and act like they never saw it before and never knew it existed. And this is what happened with the interrogation bill on the other side, where nobody came to us and said, we have problems with this other than the Department of Public Safety. Then when the conference committee went back to the Senate version, we thought we had satisfied their concern because their concern was with the House version. And then 2 weeks later, we get a veto message from the governor saying all these groups had opposition, and where the hell were they? And that's what's frustrating to me as chair. That's what I was more or less reacting to. I apologize to. We certainly want to hear from everybody, but it's just it's a frustration of the system that we seem to be living in today, where people come in at the last minute with their objections and don't get involved as we're working through the bill.
And I always hated when people deliberately don't get involved here and then just wait for it over in the House. I mean, I feel like everybody, you know, if you don't hear about it, that's one thing, and that's something where we can reach out to them. But a lot of times people pick the later part in the process because it's a more strategic.
Well, many groups now have, because we're on YouTube, hi there. Many groups have people monitoring our committee meetings, and yet we don't hear from them until it gets next door or upstairs or wherever the hell. So anyway, that was my response, and I apologize for responding. But yes, we will hear from everybody, and it'll reduce the number of bills we get to.